Tonight, a bill has just been introduced in the state Senate that would lift current restrictions prohibiting some Florida families from suing in deadly medical negligence cases. The bill follows two bills already filed in the House. All of them come after our recent impact check investigation revealed how these limitations have devastated families for decades. Investigative reporter Katie LeGrone exposed the issues to the public last month. Now she details legislative efforts to curb what critics call Florida's free kill law.
After years of quietly crushing Florida families struck by tragedy, a 33-year-old state law that prevents some families from suing a doctor or hospital responsible for the death of an unmarried adult loved one is getting new scrutiny by lawmakers.
It's like you have no rights when it comes to your loved one.
We exposed the law's impact on families last month.
I feel like I'm told her life didn't matter.
But a new bill filed in the Senate Friday is the third bill filed on the topic this fall and is likely to be the first heard in the Senate. It calls to lift restrictions for some families to sue, but only if state governing boards have already found a doctor or hospital at fault.
This is just a start. This is just the beginning.
For Sabrina Davis, if approved, the bill may finally open the door to her seeking justice 3 years after her father's death. Keith Davis was 62 and unmarried when he died at a Hillsborough County hospital after a doctor failed to diagnose a blood clot. While the state's medical board found the doctor at fault, even slapped him with a fine because of the law critics dub Florida's free kill law, Sabrina has not been allowed to take the case to court.
I have always said is a $7,500 fine was not enough for the doctor that did this to my father. With this bill, a $7,500 fine would not have been all he got.
But for other families, this new bill, they say, does nothing but leave them shocked and angry.
The larger intent of this bill is to make sure that it looks like they're doing something to take action to help. But the larger intent is the same thing the intent has been all along.
Cindy Jenkins' daughter, Taylor, was just 25, engaged to be married when she died earlier this year at an Osceola County hospital after being rear-ended at a red light. Doctors said Taylor died of a brain injury, but an independent autopsy found it was untreated internal bleeding that killed the young flight attendant. But while that autopsy was enough to convince the county's medical examiner to change Taylor's official cause of death, the State Hospital Association and Florida's Medical Board have yet to find probable cause of any wrongdoing. And that, State Health Department data shows, is typical. According to annual reports from Florida's Medical Quality Assurance Division, probable cause against a Florida medical doctor was found in just about a quarter of cases in the last 3 fiscal years.
Passing legislation that does nothing other than protect the health insurance companies in the rare instance that ACA or DOH actually makes a guilty ruling when a family has the capacity to file a complaint, it is a step in the wrong direction.
This latest bill was introduced by Republican Senator Clay Yarborough, who's chair of the Judiciary Committee. Significant because as chair, he decides which bills are heard. Efforts to repeal this law in the past have not been successful because they were never heard in the Senate. I'm Katie LeGrone. Back to you.